The choice of a lawyer is an important decision and should not be based solely upon advertisements.
Hi, my name is James Pavizian, and I'm an attorney at Parmele Law Firm. This is the first of a series of videos we're shooting to prepare you for your Social Security disability hearing. In order to get Social Security disability, we have to prove you cannot do any occupation anywhere on a national basis. In the past, when I first started doing this 12 years ago, all hearings were in person. What this meant was that you, your attorney, the judge, and oftentimes the vocational expert and hearing reporter were all in the same room talking to each other and documenting the hearing. Since COVID, that has not been possible. So Social Security has added two new types of hearings: telephone hearings and video hearings. Let's talk about the pros and cons of each type of hearing. The Social Security hearing offices have done almost exclusively telephone hearings since March of 2020. This is because it's the safest and, quite frankly, the most cost-effective way of doing hearings. From your perspective, a telephone hearing will sound just like any other telephone conversation you have in your everyday life. At the time of your hearing, you will get a telephone call from a number that's probably not going to look familiar to you. Still answer it, and what I tell all my clients is if the person that is on the other line is trying to sell you something or asking you for gift cards, hang up. However, if it's Social Security, they'll identify themselves. They'll ask you for some identification questions, and then when it's done, they'll go ahead and connect you to everyone else on the call. On the call, you'll be able to hear your judge, your attorney, the person that connected you, and a vocational expert or medical expert. Video hearings are done using Microsoft Teams. For those of you unfamiliar with Microsoft Teams, it's basically Microsoft's version of Zoom or FaceTime. What will happen is you need to download Microsoft Teams on whatever device that you're going to use for the hearing. On the day of your hearing, you should have received a link from Social Security that will ask you to click a button to join the meeting. When you click that button, the application will open up on the device and put you in the lobby of a video hearing. And when the judge is ready, they'll click a button on their end and get you connected. The third option is an in-person hearing. The in-person hearing is the old-fashioned way that we talked about earlier, where everyone is in the same room, at least you, the attorney and judge, and you're able to present yourself and your case in front of the judge. What type of hearing you choose largely depends on how long you want to wait. First, we'll talk about the telephone hearing because it's by far the quickest option. Telephone hearings are going to be scheduled rather quickly because there isn't much to coordinate. They don't have to worry about making sure they have a room available. They don't have to worry about where everyone is. The judges conduct the hearings from their home offices, and you're at your home and the attorney's at their office. The telephone hearing is the least personal of all the options, but what we found out is that it really doesn't matter as far as win rates go for a majority of the hearings held. The second option, if you don't want to do it by telephone, is a video hearing. Video hearings don't take much longer than telephone hearings to schedule. However, you have to make sure you have a device that has a webcam. That could be a telephone, an iPad, or other tablet, or even a laptop. And more importantly, you have to make sure you have a good internet connection. A video hearing is a better option than a telephone hearing because at least the judge will get to see you, at least your face and maybe above your shoulders. So between the video hearing and telephone hearing, if the technology is there and you have an internet connection, you may want to strongly consider that video hearing. And then the last option is an in-person hearing. In-person hearings are, in our opinion, the most effective. However, it's unclear when Social Security is going to go back to doing in-person hearings. So unless you have one of, I would say, a handful of conditions that would mandate an in-person hearing, this would include Parkinson's or tremor disorders, or any sort of condition where you want the judge to see the disability, such as someone using a walker or a wheelchair, then you may want to strongly consider the video or telephone options. But what type of hearing you choose is entirely up to you, and you should talk to your attorney to see which option is the best for the facts in your case. Regardless of what type of hearing you choose, the people involved in the hearing are going to be the same. In most hearings, there's going to be 5 people. It will be you, the judge, your attorney, there will be a hearing reporter, and then finally a vocational expert. The normal hearing or general hearing will last about 45 minutes. These hearings generally follow the same pattern. What will happen is you'll start the hearing off by the judge introducing himself or herself and the others involved in the hearing. They'll ask you to raise your right hand and put you under oath, and then either the judge or your attorney will start asking you questions. I want to talk to you about each person's role though. We'll start off with the judge. The judge is there to decide your case. It is the judge who is empowered by the United States government to look at the facts of your case, apply those facts to the rules that govern Social Security disability, and make a decision for the government about whether your illness, symptoms, and limitations rise to a level that's consistent with the definition of disability in a Social Security disability case. So putting it simple, the judge is the one that gets to decide everything. The judge gets to decide what illnesses are the most severe. The judge gets to decide if your illnesses meet special criteria for automatic disability. And if not, it's the judge that gets to decide what limitations are best supported by the record and whether you, with those limitations, are able to do the work you've done in the past or any other work in the national economy. Now, the judge does get some help, and that help comes in the form of vocational expert testimony. The vocational expert is not a Social Security employee. The vocational expert is there to answer general questions about the job market that both the judge and your attorney will have. Again, keep in mind, the vocational expert is not the one deciding your case. All they're doing is they are providing the judge and your attorney with general information about the job market, and then the judge will use that information to decide whether you're disabled or not. But again, the decision is entirely on the judge. You will also have a hearing reporter in every case. The hearing reporter will be silent. You will not notice them. What they're doing is they're typing in the background your information that you're telling the judge, the questions that are being asked, the answers you're given, the questions your attorney give you, as well as the testimony of the vocational expert. Finally, you have you and your attorney. You are the star witness. You are there to talk to the judge about how your conditions impact you on a day in and day out basis. You are there to talk about you. And then finally, you have your attorney. The attorney is there to present the case to the judge in language he understands or she understands, and to guide you through your testimony. They are in essence a storyteller. They're going to be telling your story, the things that are important for the judge to know, by asking you questions and guiding you through what's important for you to tell the judge. Now, the judge will also ask you questions as well, but your attorney is going to play a big part of that in the hearing. There are a few things you need to know about your testimony at the hearing and what is going to be covered. The first, though, is you need to understand that the judge is not going into the hearing blind. They have, or should have, a majority of your medical records. They will have read all your doctor's notes, all the opinions. If you had friends or family write letters, the judges will have read that. If you have submitted journals or diaries or calendars of your symptoms, they'll have looked at it. The judges will have also looked at all the opinions from the Social Security agency earlier that denied you. So they're going to have a very good understanding of the medical and non-medical evidence related to your case. You are all starting on the same page as far as what you're diagnosed with, what treatment you're getting, what medications you're taking. So you don't have to talk about that. And often in Social Security disability cases, what you're diagnosed with is not why you were denied. You are not having this hearing to convince the judge you have, for example, back pain or depression. In most cases, everyone agrees you have the conditions you have and you have the symptoms you have. The disagreement in most cases is the limitations you have because of those two things. So let me give you an example. You have an individual who is applying because they have degenerative disc disease in their back. Social Security will look at their records and they'll agree. They say, look, this x-ray shows this person has degenerative disc disease. And they'll agree that that condition will cause that person pain in their lower back. And they'll even agree that pain in the lower back is going to limit how long someone can sit and stand. But in most cases that are going to hearing, where Social Security is disagreeing with that individual is on how long they can sit or how long they can stand. And that's really the central question the judge is trying to answer. In most cases then, the reason that you're there to testify is because you and you alone are in the best position to tell the judge what your limitations are. And when we talk about limitations, we're not talking about what you feel. Again, symptoms are things like pain and anxiety attacks and shortness of breath. Limitations are things like, I can't stand for more than 10 minutes, or I cannot focus more than 30 minutes, or judge, I cannot climb a ladder or be out in the heat. Those are limitations. Those are the things you're there to testify about. Now, your attorney is going to be getting those limitations out of you by talking about your treatment, talking to you about the things you can and cannot do. What makes your back hurt? What makes it feel better? Do you rest? Do you lie down? But at the end of the day, when you're done testifying, if you look back and listen to your testimony, what you're going to notice is that you talked about more the things you can and cannot do rather than the name of your disease, the medication you take, or the symptoms you're dealing with. The judge will conclude the hearing, and if you're by telephone, ask you to hang up. If you're by video, they'll generally disconnect on their end, or if you're in person, they'll let you know you can go home and exit the room. Once the hearing is done, what we're seeing is you're going to get a decision somewhere between 2 weeks and possibly up to 2-3 months after the hearing. Now, those timetables can change. My 12 years of doing this, sometimes we're getting decisions in 2 weeks, and there were some times it was taking 4, 5, 6 months to get a decision. A lot of that post-hearing timetable depends on staffing as well as how busy the agency is. Thank you for watching the video we recorded. If you have any questions about hearings and you're represented, I highly encourage you to talk to that representative about the specifics of your hearing. If you are not represented and wish to have us review your case, we do offer free consultations, and we'll let you know very quickly whether we're able to help you or not. In either case, I do hope that this video gave you information that will help you win your case. Thank you.